As a part of the corporate tax planning program, today we will be discussing on the refund procedure or the procedure for refund, claiming refund under the Income Tax Act. Friends, whenever an assessee is filing his return of income and after total computation of the tax liabilities as reduced by the advance taxes, TDS, self-assessment tax, etc. Now, he may always come out in a situation where his tax payment appears to be higher than the tax liability. In other words, by certain situation, in a certain situation, the tax was paid higher than the tax actual liable to be paid. This may happen due to so many reasons. One of the reasons may be like tax was deducted by the banker or the person who paid the interest, where the person or the assessee concerned is not liable for tax, means his or her his income is less than the taxable limit, or in case of a business, certain deduction which are eligible for that particular assessee that has not been considered while determining the advance tax or the tax liability. Tax was paid in excess, right? And then this require a situation that crops up a situation where the assessee need to claim a refund. The situation would be slightly different but with the same result. In the entire assessment process, which we have covered in other modules, in the assessment process, when the assessment of the income of an assessee takes place under section 143 subsection 1 or 143 subsection 3, at the end of the assessment, the assessee also may come up with a situation as per the order that there arises certain amount of refund. Means the assessee claimed certain deductions, certain benefits, and the assessing officer also allowed that thing subject to all the verification under the Income Tax Act. So a refund may arise at the end of the assessment. It may also happen that the assessee taken up the matter to the higher appellate authority, say before the commissioner income tax or before tribunal, and the legal argument was going on. At the end of the entire argument process, the case has been adjudicated in favor of the assessee, and then the assessee is now required to pay, right, to be paid the amount of tax arising as a refund. Friends, this entire structure of today's discussion that's covered under section 237 of the Income Tax Act, followed by the rules and the respective forms, is covering the refund when it may arise and what are the process and how the refund can be paid to the assessee, and if there is a delay in payment of the refund, whether the assessee is eligible for a interest on the refund amount. To start with, it is very much possible that when the tax paid by the taxpayer, right, could be in the form of advance tax or TDS or self-assessment tax, is more than the required amount or the computed tax liability amount, he will be eligible to claim a refund of the excess amount of tax paid by him, and section 237 to 245, right, of the Income Tax Act deals with the provisions for a refund of taxes under the Income Tax Act. This is a fundamental basic provision of Income Tax Act. Then, as per this law, what it says? That if any person who satisfies the assessing officer, the documentary evidences, the reasons for excess payment, that the amount of tax paid by him or on his behalf, what is the meaning of on his behalf? It might be I am a representative assessee, or minor's income has been added with the parents, either of the parents. In any of the such cases, the tax liability has been deposited in excess, right, on his behalf, exceeds the amount of tax payable by him. He shall be entitled to a refund to the excess of tax paid by him. So, under Income Tax Act, when if there is a shortfall is also payable. Interest on shortfall is also payable, while if there is a refund arises, the refund amount also is liable to be returned back to the assessee. Now, question comes up, who is entitled to claim the refund? Who? As per the normal procedure, the assessee himself, say in case of individual, the individual himself; in case of a company, the person who filed the return, that is the managing director; in case of a trust, the managing trustee; in case of a partnership firm, the managing partner. Like, who is eligible or entitled for filing of the refund, right? Who paid the tax is entitled to claim the refund of the excess amount of tax paid by him or her, or by the entity. Entity means company or trust. Now, there may be certain special cases in which the refund is to be claimed by a person other than the payer. It's like the income of special. What are the type of special cases? Like, income of one person is included in the total income of another person. Under any of the provisions, say clubbing of income provisions, like wife's income has been clubbed with husband's income, minor child's income has been clubbed with the parent's income, either of the parent's income, etc., then the latter shall be entitled to a refund in respect of the clubbing of income, as well as the tax to the extent excess paid, right? There may be another special situation is possible, that death, incapacity, insolvency, liquidation, or any other cause, right? If a person is unable to claim or receive any refund, okay, which is due to him, which he is eligible to get, his legal representative or the trustee or the guardian of the receiver, say minor child and the guardian, right, shall be entitled to receive such refund for the benefit of such person or his estate. So, these are the special situation, exceptional situation. Excepting to this two situation, everywhere the person who paid tax in excess is eligible for a refund under the Income Tax Act. What the rules and the forms speaks about, because if there is an act to enabling the act to make it the proper modus operandi, certain rules, procedures and forms has been established. The law says that there is a particular form number 30, right, which normally need to be filled up and submitted by the assessee along with the return, wherein he says that by mistake or by by some calculation or by some other reason I have paid some extra amount of taxes which I seek for a refund of it. So, the taxpayer has to make a claim for refund in a particular prescribed form number 30, duly filled in and signed with all the necessary details as may be forming part in that particular form, giving the reasons, giving the total income, giving the taxable income, giving the nature and amount of tax paid, that is say TDS and advance taxes, and finally coming out with the amount of taxes that need to be refunded back. Once this form is submitted, then the entire process of a refund that starts up, that continued at the part of the department. And please remember, the refund is not an automatic process. The assessing officer need to take into cognizance the amount of income that has been declared, the amount of taxes that has been paid, and obviously after the proper assessment process is completed. Once this forms and other things that has been submitted, a question that always comes out, that if a return has been submitted delayed, or the assessor submitted the claim for the refund which is also in delay, can he or she be eligible for the refund? That means, in other words, a belated application or a supplementary claim of refund, claim which is in addition to the amount of refund after completion of the assessment for the same year, can be admitted. That means you have already claimed something, assessment is now over, it is found out that some more amount of claim you have forgotten to claim, and you are now claiming it. The law says, the law permits that it can be admitted with a condonation petition, right? Condonation petition, provided that the other condition and referred upon are fulfilled. So these other conditions and the details modus operandi, the Central Board of Direct Taxes had issued a specific circular and clarified this position by circular number 9 of 2015, that when under what circumstances such a condonation may be accepted, and provided what conditions need to be followed to accept that delayed or belated submission of the refund claim. If the refund is allowable or eligible in respect of an appeal, right, it's like that in case where the refund becomes due, very much possible, and as a result of any order which is passed by any appellate authority, say commissioner appeal or a tribunal or any other proceedings under the act, the assessing officer shall, except as otherwise provided in the act, refund the amount to the taxpayer without his having to make any claim in that behalf. It means to clarify that if in an appeal, that means the higher jurisdictional authority decides that some amount of refund to be paid to the assessee, the assessing officer, when this order comes to the assessing officer should process the refund, should clear the refund, should pay off the refund, and what the law says, what the act says, that refund of the amount to the taxpayer without having to make any claim in that behalf. That means out of the refund he cannot say that you have got a demand and adjust it. But this is covered under section 240 of the Income Tax Act. But there are also possibilities where the assessing officer may request the assessee that this particular year you have a refund, and in another year you have a demand, you have something amount to be paid to the government. Why not you are making an adjustment of that, setting up of that. Section 245 allows this setting up. So this is also permissible under the provisions of the act. Finally, we are coming to the situation where if the refund is processed delayed, or if there is a delay in processing the refund, assessee gets the refund after the due date, then what will happen? Is he eligible for a interest? The law says 244 capital A of the Income Tax Act provides this situation. It says that if the taxpayer do not get the refund in due time, in such a case he is granted interest on the delayed refund for the period of the delay. The provision is covered under section 244 capital A of the Income Tax Act. And what it says? It says that for the refund amount arising out of a particular order or claim payable to the assessee, right, by way of advance tax, that the taxpayer shall be entitled to an interest calculated at the rate of 0.5% per month. 0.5% means annually it comes to 6, annualized 6, or per month 0.5%, 1/2% interest on such case be allowed for a period commencing from first day of April of the assessment year, that means the beginning of the assessment year, to the date on which the refund is granted. And if there is a delay in this process of the refund, obviously the amount of interest that goes on. However, there is no interest shall be payable if the amount of refund is less than 10% of the tax as determined under section 143(1). What is 143(1)? 143(1) is the prima facie assessment, the assessment of the assessee where it says that if the total tax demanded is 100 rupees and your refund is say 5 rupees, which is less than 10% of the tax demanded, then interest shall not be payable, right? Interest shall not be payable if the amount of refund is less than 10% of the tax that has been finally determined in the assessment process. And interest on refund which arises from appeal effect, interest on refund which arises to the TDS deductor, in all these cases the refund is definitely paid along with the interest as applicable. So friends, to sum up whatever we discussed in this chapter, we covered up the provisions of the act relating to refund, the provisions of the Income Tax Act relating to eligibility and the situation where refund arises, the procedure, the particular form, the due date, delayed submission of the application, what will happen, and then if there is a delay, who will be liable for that delay, and whether interest is also eligible on the refund amount. With this, we have covered the entire topic of refund under the Income Tax Act. Thanks, my friend, for being with Netaji Subhash Open University in the corporate tax planning program. Thank you.